So, for rules 123, 124, and 125, hindi siya gaanong tinatanong sa par. So, we will just read the provisions of 123, 124, 125 para lang makomplete natin ang ating rules. Okay, Rule 123, the procedure in the municipal trial courts. Section 1, uniform procedure. So, the procedure to be observed in the MTC shall be the same in the RTC, except where particular provision applies only to either of the said courts or in criminal cases governed by the revised rule on summary procedure. Rule 124, procedure in the CA. So, in all criminal cases appealed to the CA, the party appealing to the case shall be called the appellant and the adverse party the appellee, but the title of the case shall remain as it was in the court of origin. Appointment of counsel de officio. If it appears from the record that the case is transmitted that the accused is confined in prison, is without counsel de parte on appeal, or has signed the notice of appeal himself, the clerk of court of the CA shall designate a counsel de officio. The appellant who is not confined in prison may, upon request, be assigned a counsel de officio within 10 days from the receipt of the notice to file brief, and he establishes his right thereto. Section 3. When a brief for appellant is to be filed. So within 30 days from the receipt of the appellant or his counsel of the notice from the clerk of court of CA that the evidence, oral, documentary, is already attached to the record, the appellant shall file 7 copies of the brief with the clerk of court, which shall be accompanied by proof of service of 2 copies thereof upon the appellee. Section 4. When the brief for appellee to be filed, reply brief of the appellant. So within 30 days from the receipt of the brief of the appellant, the appellee shall file 7 copies of his brief, and then 2 copies thereof upon the appellant. Within 20 days from the receipt of the brief of the appellee, the appellant may file a reply brief traversing the matters raised in the former but not covered in the brief of the appellant. Section 5. Extension of time for filing brief. An extension of time will not be allowed except for good and sufficient cause, and only if the motion for extension is filed before the expiration of the time sought to be extended. Form of briefs. So briefs shall either be printed, encoded, typewritten, double-spaced on a legal size, good quality, unglazed paper, 330 mm in length, 216 mm in width. Contents of the brief. It shall have the same contents as those in Section 13 and 14 of Rule 44. A certified true copy of the decision or final order appealed from shall be appended to the brief of appellant. Dismissal of appeal for abandonment or failure to prosecute. The CA may, upon motion of the appellee or motu proprio or with notice of the appellant in either case, dismiss the appeal if the appellant fails to file his brief within the time prescribed, except where the appellant is represented by counsel de officio. The CA may also, upon motion of the appellee or motu proprio, dismiss the appeal if the appellant escapes from prison or confinement, jumps bail, or flees to a foreign country during the pendency of the appeal. Section 9. Prompt disposition of appeals. Appeals of the accused who are under detention shall be given precedence in their disposition over the appeals. The CA shall hear and decide the appeal at the earliest possible time with due regard with the rights of the parties. The accused need not be present in the court during the hearing of the appeal. Section 10. Judgment not to be reversed or modified except for substantial error. So no judgment shall be reversed or modified unless the CA, after an examination of the record and the evidence adduced by the parties, is of the opinion that error was committed injuriously, which injuriously affected the substantial rights of the appellant. Section 11. The scope of judgment. The Court of Appeals may reverse, affirm, or modify the judgment and increase or reduce the penalty imposed by the trial court, remand the case to the RTC for new trial or retrial, or dismiss the case. The power to receive evidence. So the CA shall have the power to try cases and conduct hearings, receive evidence, and perform all acts necessary to resolve the factual issues raised in the case, falling within its jurisdiction, involving claims for damages arising from the provisional remedies, where the court grants a new trial based only on the ground of newly discovered evidence. Section 13. The quorum of the court. 3 justices of the Court of Appeal shall constitute quorum for sessions of a division. The unanimous vote of the 3 justices of a division shall be necessary for the pronouncement of judgment or final resolution, which shall be reached in consultation before the writing of the opinion of the member of the division. In the event that the three justices cannot reach a unanimous vote, the presiding justice shall direct the raffle committee of the court to designate two additional justices to sit temporarily with them, forming a special division of five. The designation of such additional justices shall be made strictly by raffle and rotation among all other justices of the Court of Appeals. Whenever the CA finds that the penalty of death, reclusion perpetua, or life imprisonment should be imposed in a case, the court, after discussion of the evidence of the law involved, shall render judgment imposing the penalty. However, it shall refrain from entering the judgment and forthwith certify the case and elevate the entire record thereof to the Supreme Court for review. So, pag reclusion perpetua, death, and life imprisonment, it shall refrain from entering the judgment forthwith to certify the case and elevate the entire record of the case to the Supreme Court for review. A motion for new trial. At any time after the appeal from the lower court has been perfected before the judgment of the Court of Appeals convicting the appellant becomes final, the latter may move for new trial on the ground of newly discovered evidence. The motion shall conform with the provisions of Rule 121, where new trial is conducted. When new trial is granted, the CA may conduct the hearing and receive evidence provided in Section 12 of this rule or refer the trial to the court of origin. Reconsideration. So, an MR shall be filed within 15 days from after the notice of the decision or final order of the CA, with copies served upon the adverse party, setting forth the grounds in support thereof. The mitimus shall be stayed during the pendency of the motion for reconsideration, and no party shall be allowed a second MR of judgment or final order. The judgment transmitted and filed in trial court. When the entry of judgment of the CA is issued, a certified true copy of the judgment shall be attached to the original record, which shall be remanded to the clerk of court from which the appeal was taken. Section 18. Application of certain rules in civil to criminal cases. So the provisions of Rule 42, 44 to 46, and 48 to 56 relating to procedure in Court of Appeals and in the Supreme Court in the original and appealed civil cases shall be applied to criminal cases insofar as they are applicable and not consistent with the provisions of this rule. Rule 125. The procedures in the Supreme Court. So it must be uniform unless otherwise provided by the Constitution or by law. The procedure in the SC, in the original and the appeal cases shall be the same as in the Court of Appeals. The review of decisions by the Court of Appeals. The procedure for review by the Supreme Court of decisions in criminal cases rendered by the CA shall be the same as in civil cases. And Section 3. Decisions if opinion is equally divided. When the Supreme Court en banc is equally divided in opinion or the necessary majority cannot be had on whether to acquit the appellant, the case shall again be deliberated upon, and if no decision is reached after the redeliberation, the judgment of conviction of the lower court shall be reversed and the accused is acquitted. So that ends Rule 124, 125, and 123, 124, and 125.